My name's Graeme Black. I'm a partner here at Harrington Carmichael in the Private Wealth and Inheritance team, and this is my colleague Anna, who's a trainee in our team. This afternoon, just afternoon now, we are going to talk to you about some of the purposes of wills. It's a bit of a misnomer, the title, the purpose of wills. There are lots of different purposes, but we're going to run through some of the key drivers why people might consider preparing their wills, and some of the considerations that people will have in respect of the same. So what we're looking at today, we've chosen a selection of things that come up routinely with clients that we advise. We're going to look through a little bit about appointing guardians, which Anna's going to speak to you about, talking about providing for specific people, including those with additional needs, which I will speak about, providing for your pets, which again, Anna's going to speak about, then planning for inheritance tax and mitigating care home fees, which I will speak to you about. And then Anna can finish off with exercising your right to choose. Then we'll have some questions at the end. What I will say is if you have questions as we go, I think everyone's muted, so please put them in the chat and we'll answer them at the end as they crop up, or if you have some questions at the end, then again put them in the chat and we'll respond on the call to those questions. So let's begin. Anna, are you all good?
I am. Thank you, Greg.
Excellent. Over to you.
So as Graeme said, one of the key benefits of making a will is the ability to appoint guardians. This is very important for anyone who has any children under the age of 18, as it allows you to make provision for who's going to be looking after them in the event of your death. In terms of who can be appointed a guardian, it's possible for anyone over the age of 18 to be appointed. Most commonly, people will choose a close family friend or a family member, but it can be anyone who you think is an appropriate choice. Choosing a guardian is particularly important because organising who is responsible for a child's welfare can easily become a point of contention between people when someone has died, which is already a really difficult time and you don't want to add to that. And it's good to have someone named in the will because the decision is essentially already made. Additionally, if there is no guardian appointed in a will, it will be for the court to decide who the child is going to live with, and that won't necessarily be someone who the child knows as well as someone else who might be a better choice. And that is something that you might just want to think about when choosing a guardian in your will. It's also good to know if you have particular wishes for how you wish your child to be raised. That could be, for example, a particular religion that you want them to follow, or a particular parenting style, as we have here. There might be someone in your life who is particularly appropriate to fulfill those wishes, and you might want to consider appointing them as the guardian for your child rather than someone who doesn't fit that sort of framework for you. As we have here, it's the reason appointing a guardian is so important is because they essentially become the parent to your child. So it's something that should be given a lot of thought before including in your will, but something that should be considered by anyone who does have children. I'll pass back to Graeme for the next one.
Thank you. So I'm going to talk to providing for individuals with additional needs and indeed for specified individuals for whatever purpose, really. Within a will, it's possible to make a financial provision of a specified sum, £5,000, £10,000, for instance, a specified percentage of the residue, 5%, 10%, 50%. The advantage of percentages being that they fluctuate with the value of the estate and the value of the assets. So if you've won the lottery, the percentage will be worth a significant amount more, but the percentage remains constant, and it reflects the relative importance of any individual within your will. You can name individuals, people who matter to you, whether they be family members or whether they're friends or charities. So you can always make a provision for specific people that you don't have to. It doesn't have to be a generic my children, for instance. It could be for my gardener, for my next door neighbour, for my friend Fred, and then making provision for the rest of it to pass to people. The key thing that we wanted to speak about today is really making a provision for people who do have additional needs, whether they be physical or in terms of their neurodiversity or their neural situation, being that there are a number of ways of securing funds for their benefit to ensure that they continue to benefit from whatever it is that you set up, whether that be by way of leaving them some money that they can use to purchase a property with a specific instruction that it be used for that. If it's leaving them some money in some form of a trust, whereby they receive the income from it, so it allows them to continue to live their life without it affecting too significantly the benefits that they may receive from the state or their underlying care that they receive. Specifically, particularly if it's not a vast sum of money, the income could be used to help to contribute towards holidays or some additional care needs, but won't necessarily erode the benefits that they receive and the care that they receive in the underlying nature from the government. There is a particular form of trust for people who are vulnerable. It is a vulnerable person's trust, and it has a number of benefits which are applicable in terms of the tax treatment of the income and the underlying capital, which are very specialist areas, and we would recommend anyone who has, we see it more and more. We have families with children who have severe learning difficulties. We see families with friends or relatives who've got a very specific needs. We can always advise clients around how there is a benefit to trying to create one of those specific types of trust and what the criteria are to enable the trust to benefit from the improved taxation regime. It's important to understand those because it can make a fundamental difference to the amount that the vulnerable person may receive and that they would be able to use for their benefit moving forward, or their supporters, their carers, their attorneys, whomever else would be able to use and apply for their benefit. So specialist advice is something that we do quite a lot of, and it's just worth bearing that in mind. It's really important because they're sometimes the people that we're worried about the most, because they're the ones who will never be able to fulfill their wishes, their needs, their desires, their dreams on their own. They will always need some level of support. And if we can, as parents or as concerned family members or friends, put something in place which allows that to stretch as far as possible, and we can also understand that there is a tax benefit to doing so for that individual, we can really start to make a sound financial plan that helps to make sure that they are supported and that they're not damaged in any way by receiving a significant sum, because vulnerable people by their nature are sometimes vulnerable to predatory behaviour by other people, and we can ensure that these things are properly looked after for them. So it's a really important point, something to consider where families do have individuals with vulnerabilities. But to go back to that first point that we started with, specific sums of money, specific items, percentages of the residue of the estate can be allocated to individuals, whatever their nature, whether they're vulnerable or otherwise. But with regard to those who are vulnerable, there are a number of things that we can do to try and ensure that whatever you do set aside for them goes as far as it possibly can. And then I think I'm going to hand back to Anna now to talk about pets.
That's right.
Another really emotive topic for people.
Yeah, so as Graeme says, I'm going to just quickly touch on how you can provide for your pet within your will. I think for many of us, we consider our pets part of the family. So it makes sense that you would want to provide for your pets in the event of your death, which is not something the intestacy rules allow for. There are a few different ways you can provide for a pet in your will. But one sort of important thing to note is that even though we do often consider our pets as part of the family, under law, they are considered personal chattels or property. So you can't leave them a cash sum directly, for example. One way you can provide for your pets is sort of similar to what I was speaking about just a moment ago. You can appoint a pet guardian. So that is someone who's going to be appointed to look after your pet in the event of your death. That could be, again, a friend, a family member, whoever you think is best placed to look after your pet. And that's something you can include in your will. And while you can't leave Fluffy the cat 50 grand in your will, you can leave money to your pet guardian for the specific purpose of looking after your pet. So that gift would essentially be tied to the obligation to use that money to look after your pet. So it's not a direct inheritance for your cat, dog, lizard, whatever it is, but it is going to be used for the purpose of looking after your pet, which is desirable and not something the intestacy rules can do. You can also include a letter of wishes, which will provide for sort of directions on how you want your pet to be looked after. So that could be who their vet is, what their microchip number is, and sort of day-to-day routines that you'd like for your pet to still follow once you've passed away and someone else is looking after your pet. So that's a really powerful way you can still look after your pet in your death, even if you can't give them money directly.
Thanks, Hannah. We're going to talk a little bit now about inheritance tax planning. we're not going to go into a great deal of detail. We don't have time for that. We could do an hour-long webinar on IHT planning on its own, as we could probably on each of these topics. This is a bit of an overview just to try and run through with you. Inheritance tax planning. We're told that last year the government took £8.9 billion in inheritance tax from the people who were unfortunate enough to die last year and pay IHT last year. We know that there's a lot of fiscal drag in respect to the nil rate bands. The £325,000 has remained the nil rate band since 2009. It's locked in until 2030, 2031, and it's not going to be changing anytime soon. So as we, broadly speaking across society, property prices have been increasing. People have, although it doesn't necessarily feel like it, been earning a little bit more money, paying a bit more tax during their lifetime. We're also unfortunately paying more tax on death, and we do have a number of clients who want to talk about inheritance tax and how that can be mitigated, and there are a whole range of tools which are available, but this is about why you would draft a will. If you didn't have a will and you were married with children and you had a relatively sizable estate of over £1 million, you would end up paying inheritance tax on the first death of the mother and father under the intestacy rules. And we're keen to try and avoid that and get the education out there so that people are aware. Just by being together, by being married, by cohabiting, by being civil partners, it does not mean that everything is going to pass to each other and that there is not going to be an inheritance tax. Gifts between spouses, civil partners, do not attract inheritance tax, but that under the intestacy rules does not provide for the entire estate to pass to the surviving spouse or civil partner, and therefore an unintentional trigger and an unintentional charge, I should say, to inheritance tax can be triggered on the death of the first spouse to die, which would generally not be in anyone's interest other than that of the Chancellor of the day. It's really important that we are aware that the intestacy rules do provide, we have a little summary on the slide there, that they do provide for £322,000 to pass to the surviving spouse or civil partner, with the rest of the estate to be divided between the children and the surviving spouse. Now, of course, if there are no children, then they pass out to siblings, parents, nieces, nephews. The intestacy rules are far-reaching, but in this scenario, if you had an estate that was worth over £1 million, you would end up paying inheritance tax on the first death, and the surviving spouse would not inherit everything, which could, of course, curtail their own aims and objectives and ability to live the life in which they've become accustomed, and that can cause problems. It's bad enough that you've lost your husband or wife of many years, only to be told that you can no longer afford really meaningfully to live in the property that you have been in for a significant period of time, or that you don't have the funds available to you to fix the roof or the boiler because it's gone to your children. Now, there are ways around that. It's possible to do a deed of variation currently, but one would never be advised to rely upon that. That doesn't seem like a sensible thing, to leave it to chance, and the law hasn't changed. So a will properly drafted which leaves everything to your spouse or civil partner will automatically mean that there is no inheritance tax payable on that first death. And if that's the only thing that you do and you can save some inheritance tax, it's absolutely worth doing a will just for the purpose of doing that for the inheritance tax, on the basis that you want everything to pass to your surviving spouse. The reason being that children, grandchildren, nieces, nephews, and all of those other individuals are not exempt from inheritance tax, whereas any gift between spouses on death or in life is free from inheritance tax, regardless of the value. So, and when I say spouse, that includes civil partners. So it's just worth bearing in mind that if you think you have an estate which might be taxable, and you're not worried about pets, you're not worried about guardians, your children are grown up, you're not a pet person, you don't have anyone vulnerable in your family, there may still be a pressing need to prepare a will, which at the very least leaves everything to your surviving spouse. And that can make a very significant difference. It will give you £1 million free from inheritance tax if you have children and you're leaving your estate to your spouse and then to your direct descendants under the law as it stands at the moment, and something that we do advise people to consider very carefully. Whistle stop tour, trying to control what happens with the intestacy rules and wills, but lots more information available on that if people have queries on it. But we will move on to care home fee mitigation. People are coming to see us more and more, and they're concerned about the situation that they've experienced with their parents, with their brother, with their sister, where they've gone into a care home or had care at home, and they've spent an awful lot of money on care. People spend a lot of money on care because care is very expensive, and where care is done properly and it's done right and it's effective, that's money that is very well spent. We do say to clients that as a general starting point, we don't really think that people should be putting assets beyond reach that mean that they can't choose their care. We think it's really important that people have access to assets to enable them to have the standard and the level and the quality of care that they deserve, because no one wants to be left at the behest of some third-party organisation who will determine where and why you go to stay and live, when you have the means or could have had the means to make sure you received really good care. So we always predicate all of the advice that we give around this on that basis. We do want our clients to have the care that they are entitled to and that they could afford to have. It's really important. But there are ways of mitigating that and making sure that not everything disappears into care costs, which are legitimate and are a well-trodden path. There are a number of trust structures that can be used, and they can be used without meaning that the surviving spouse or the beneficiaries of the will, if not a spouse, can continue to live the life that they're accustomed to, and they effectively postpone, if you like, the care fees until a bit later on, so the surviving spouse can still have the use of the property, for instance, but when they die, then some of those assets may be applied to the care fees that the first spouse would have paid at the time if they had the capital available. I think we do have a number of people who are, as I say, very concerned about the erosion of their assets and their entire estate by way of care home fees. In reality, wealthy people with good advice are able to take a number of different options in respect of their finances and advice around what they ought to be considering. And we work closely with financial advisors with people to help build a meaningful financial plan that will give them the comfort and the satisfaction, the knowledge that they know that if they're putting their will in place and they're using potentially some form of a trust structure, or they're making sure that their assets are passing to where they want them to go to, that they will be able to do that while also being able to afford the care fees that are likely to apply if something were to happen to them. And there are a number of different ways of funding care. So we have those conversations with clients, but the key thing to bear in mind is that if there is no will drawn up, there will be no form of trust structure which can protect and at least delay, if nothing else, some of the fees which would otherwise be applicable when the first of the spouses or civil partners became unwell and needed care. So it's another driving force for preparing a will, and to take that advice and make sure that you are considering how the future may look in respect of the funding of those fees, and making sure that you are funded enough, sufficiently well funded, to make sure you have good care and in a good environment, because, you know, as I say, there's very little that's more important than that when you are vulnerable, if you become in that way, and the care that you receive will allow you to remain comfortable, protected and safe. And those are really very important things for our clients, and we do always stress the importance of those elements versus the potential for trying not to spend too much on care. We're going to move on to being able to exercise your choice, Anna.
Which I think is one of the key benefits of making a will, is in fact the ability to exercise your choice. And we've outlined some key areas here where we think that's particularly relevant. The first of which being the intestacy rules are archaic and do not reflect modern society, blended families, or the needs of people in the 21st century. One example of this would be, for example, stepchildren are not automatically entitled to inherit under the intestacy rules, and that applies even if you've been this person's step parent for 50 years. There is no automatic entitlement under the intestacy rules if that stepchild has not been adopted by you. In a society where there's more and more blended families, this doesn't necessarily reflect what people want, so it's something that it's really important to consider within your will if you have, for example, stepchildren. That's just one example. Additionally, I think more and more we're seeing people who have a sort of chosen family, which is not necessarily people who are related by blood. They're just people who you've become incredibly close to and who you see as family, even if they're not blood related to you, and those people wouldn't be entitled under the intestacy rules. So if you wanted your chosen family to inherit under your estate, you would need to provide for that in a will. Second one we have here is taking no action can result in those who you want to benefit from your hard-earned labours being excluded or not inheriting as much as you would want them to. This is similar to the first point, but I would also just add that you may have been having conversations during your lifetime that you had every intention to benefit your best friend or your neighbour, whoever it might be, and you've had those conversations, you had every intention to do so. If it's not in your will, they are not automatically going to inherit under the intestacy rules, which can be really disappointing for people if they have had those conversations. And it just adds another layer of complication when you could just have it set out in your will that you want those people to inherit because you've worked hard and you know who you want to inherit, and your will can allow for that. Third one we have here is you can choose to leave assets outside of your family and or to organisations or charities, none of which is accomplishable under the intestacy rules. I've sort of touched on this already a little bit, but in terms of charities, let's say, for example, you have been an avid supporter of a charity for your whole life. You've been to fundraising events, you've donated monthly, you've given large cash sums. You want to leave a gift to them when you die because you have money in your estate that you would like to do that. Under the intestacy rules, they will not have any entitlement. It needs to be specifically written in your will. You can leave charitable legacies to those charities to make sure that they are getting support from you if that is something you would like to do, which is not possible under the intestacy rules. The same goes for friends or other organisations, as we say. And the final one we have here is you have the power to exclude people from your will if you choose to, which is again not possible under the intestacy rules. We get quite a few cases where there's been an estrangement in the family, for example, between a parent and a child, and for whatever reason, the parent maybe doesn't want their child to inherit under their estate. Under the intestacy rules, that child would likely be be entitled under the intestacy rules to a share of your estate. So if you would want to disinherit them, so to speak, in your will you can have a non-benefit clause which specifically states that no, I don't want my child to inherit. You can include a letter of wishes or a witness statement saying that these are the reasons why, if you so wish. And then it also just sort of mitigates against future claims that, the child comes along and says, no, my dad fully intended for me to inherit, but just forgot about me. Having a non-benefit clause clearly states that no, they weren't forgotten. It was a conscious choice not to have their child benefit. So that's just a really powerful tool that is not possible under the intestacy rules. So I think the sort of key overarching point here is that wills allow you to have a degree of autonomy and freedom of choice that the intestacy rules just don't allow.
Yeah. Well, and so we do see that a lot more now, don't we, with people trying to exclude people from their will for whatever reason. And as you say, under the intestacy rules, they would inherit, and that could be something that might have people turning in their grave if they realise that, right? So, exactly. Yeah, brilliant. Thank you, Anna. And we are largely finished. Please, if there are questions, put them in the chat. It'd be great to answer any questions if there are any. And we just finish with our contact details if you'd like them. Anna's email address is not precluded by those telephone numbers. It's a telephone number and then an email address, but those are our details there. So if there are any questions, please type away and we'll give it a couple of minutes. Otherwise, thank you for joining and enjoy the rest of your Thursday. Right, there don't seem to be any questions coming in. So on that basis, we will say goodbye. Thank you again for joining. And if there are any questions, please do give us a shout. You've got our contact details there. Thank you very much.